structuring or doing something that added an actual manual step as the step after the mental step, they have been going away. Almost every case I've seen have gone away in the last 6 months. So there is light at the end of the tunnel.
It's funny you say that. I hear that, and I think that's accurate as well. But I also use another trick. I use this. It's called Patent Core, and I do an analysis. First of all, at the USPTO, I had probably 8,000 examiners, which means I had 8,000 patent offices. Everybody seems to apply things in a different manner. And if you look at the analysis, which is done in Patent Core, and others do it as well, but that's the one I use, you can see what the allowance rate of a particular examiner is vis-a-vis an art unit, vis-a-vis a group. So you know what goes to those examiners, what types of claims by the classification system. You can draft your claim to try to get it to an art unit that has a higher allowance rate just by changing the nature of the way you're claiming things. And you will have a better chance at allowance by doing that too. So there are many tricks that if you use together, you have a better possibility of getting a patent. And that's kind of what I've learned from the outside looking in at my examiners. A lot of them have very similar subject matter but have very different allowance rates.
Coming from a long-term patent office commissioner, I go with that. I'll take one more question.
Just a comment from the panel, possibly on the issue of adding a treatment step to the claim. In Europe and UK particularly, we would worry about enforcement of such a claim, particularly for diagnostics. And I understand the problems, it's more complicated in the US because of how you can establish infringement. So maybe that's not the solution we're looking for.
I hear your comment, but in order to get enforcement, you need to have a patent. So I hear you, but I don't have much choice in the United States. I have to add it now.
All right, go to the next topic. Essentially, this deals with claim interpretation and the role of the specification in claim interpretation. Now, ordinarily, that seems pretty straightforward, but it deals with a little bit of the philosophy of language type issue. Now, take it water, yeah, it's the thing that falls from the sky, when it occurs, that's the concept you have of water. Let's say in the specification you would define water to be H2O. Which is right?
Ask somebody who may not have first.
I didn't hear the end of your question. You define it to be H2O?
Yeah. The specification to define water to be H2O.
So, in South Africa, I think you'd find again a very pragmatic approach. Well, the rules of interpretation are read the claim and give it its plain English meaning. So, absent the specification, just read the claim and give it its plain meaning. If you can't understand the meaning of the claim, if you can't understand words, look in a dictionary or look in the specification. So, you could limit yourself in the specification. You could give a dictionary, your own dictionary in the specification by saying, when I say H2O, I mean water in all its various forms, etc. You could do that. But again, I think if it ever got to issue, you would simply have and I say simply, but you would have a skilled person, an expert, who would either say, I don't know what is meant by H2O, or I think it's so limiting that it can only have this meaning, or more likely you will have a skilled person who says, but of course any skilled person would know what this means. H2O is just one way of representing a common concept of water. So I think we would have a very pragmatic approach, and I don't think we would be unduly limited or influenced by that in the specification.
So
Yeah, our standard is that we have to based on the plain language, the same as South African case, and plain meaning of the plain language. But if there's some definition in the specification, then water is H2O. That's probably limit the claim, the scope of the claim. So they if the applicant exclude the very dirty water or something like that. So if there is a meaning of the specification, the designer will get the specification.
The way I do it in the United States is the applicant is his own lexicographer. So I believe you can define terms in a manner that explains and limits them by putting the limitation to the specification. There is a movement now to basically have a glossary in the United States. The AIPLA is opposed to it, and that is because term meanings change over time, and there are many different terms that could have many different multiple interpretations. I really do believe, though, that we would save us a lot of Markman hell if we in fact did have some sort of glossary that said it is done. I think that the practicing attorneys, of which I guess I'm now one, want that flexibility, but I see a logical basis for a limitation based upon statements made in the specification and some sort of glossary or a type of definition that would make things clearer to the public and being beneficial to everyone. So I think we're going to move more in that direction.
As a follow-on, how do you look at the BRI back in light of what you just said?
We're asking difficult questions. The bar does not want, for example, in post-grant procedures, BRI, the broadest reasonable interpretation, to be the standard for those post-grant procedures. And I can understand why we, I guess now in the bar, feel that way, but the entire idea of the broadest reasonable interpretation in post-grant procedures, and I'm talking about inter-parties review, post-grant, and covered business methods, is because you can amend your claims at that point. And the problem with that has been, in practice, is the PTO has been limiting the ability of patentee to be able to amend their claims, which kind of leads you into this tighter standard. So either the PTO has to be more permissive in allowing amendment of those claims, or the standard has to go to the court standard.
One point on the software side of things.
I agree everything that Bob said. And just a little background with broadest reasonable interpretation. When you ask yourself, how does the specification influence a claim interpretation, you have to ask yourself, what jurisdiction are you in? Are you in front of the USPTO or are you in front of a district court? In the district court, you're not going to be using the broadest reasonable interpretation. You're going to be using the what they call the Phillips standard, where you're going to apply the customary and ordinary meaning of the claim language itself to the claims. So, in a district court, according to Phillips, how you interpret the claim depends on whether you're going to use there's intrinsic evidence and extrinsic evidence. So, intrinsic evidence is the preferred evidence for interpreting a claim. That's going to be the claim language itself. It's going to be the specification and the prosecution history, which we'll also get a little bit into a little bit later. And then extrinsic evidence, it's going to be things that are outside of the patent, like a dictionary, an expert declaration, and such. And so, so where does the specification fall into that? It's intrinsic evidence, so specification will be viewed as giving more weight to claim interpretation compared to a dictionary definition or expert testimony. And that's also even true, I guess, even if you're using the broadest reasonable interpretation for the PTAB. The PTAB will also look at your specification before they consider a dictionary definition. Simultaneously, they'll also look at your expert declaration, but I guess it also depends on your panel as to whether they'll consider your specification or your expert, how much will they get your specification compared to your expert declaration.
Again, following up on the same idea. Let's say you make some statements in the background. Okay. How is that going to affect? I mean, as far as I can see, background is part of the specification, but it's very clear from the way you say it that you're talking about the background.
So, in the United States, we have something called Miranda rights, where if you get arrested, you are advised of your rights that anything you say can and will be used against you in the court of law. When I advise a client, I pretty much advise them the same thing. Anything we state from the beginning of our transmittal letter to the end, up to the very last page of our prosecution history is fair game to be used against you by the examiner, by the PTAB, or in front of whether you're in the district court. So you got to be careful as to what you put in your background. General practice is to keep the background short and cursory, but as Bob mentioned before, in light of Alice, you got to have more details in your specification. You got to round it up. So you still want to keep your background cursory. You don't want to make as many admissions. You want to limit your admissions, but to comply with Alice, you still want to make sure that you're very clear on what the technical problem is and what your technical solution is. So I always advise clients to be careful on what we state, on what we're saying, either in prosecution or in our background. And if they get arrested, they should call me before they talk to the police.
So Harori, what's your comment on Japanese practice regarding statements?
Unlike the United States, we do not have the admission. So we can say anything in the background. So background is just one section of the disclosure. So we can say, oh, this is disclosed in the public, but is it not true? It's okay.
I don't think we've had a decision on this, but I would tend to go with the Japanese position. Of course, you actually need evidence. If you were attacking patentability or novelty or obviousness, you would actually want to see that prior art document produced. So a statement in the background which says something, I don't think that's going to be evidence of prior art, and it's filed at the same. You couldn't use it, and I think you would probably be safe. Although I wouldn't be reckless about it at all. I'd be quite careful.
So in South Africa, if I file a patent application and I say in the background, this A, B, C, and D were invented by somebody else before I conceived and reduced to practice this application, that would not be something usable against the application itself.
Simply because I don't know that having been decided. My guess is, on a practical scale, you probably wouldn't be saying that. But if you did say that, yes, I think a judge might look at it and say, but come on, you've told me that it's been done. So practically, I wouldn't do it. An interesting approach. Again, the judges are being led typically by an expert. And if the expert says, well, that, I don't really agree with that, I can't see any evidence, I don't think so. I think the judges would be led by that more, but I wouldn't take a chance.
So the practice of having a big blog as to specification, as Professor Caton, professor for a long time, is probably not going to work today, and I never thought it worked then either, but more and more, likelihood of it not working at all. Okay. Any questions on these topics, on the topic of saying, yeah?
Rajiv and Anand and Anand. I had a question regarding claim interpretation, specifically on the issues you just mentioned. On the one hand, I'm hearing that claims are interpreted in isolation of the detailed specification. It seems to suggest that specification is something superfluous and need not be considered at the time of enforcement. And only the plain English language interpretation of the words of the claim and the language of claims matter. Sometimes that leads to a completely different understanding of the invention. If you just read the claim in isolation without, let's say you have not even read the specification at all, you simply read the claims. What comes through at times is a totally different story from what the inventor set out to solve, the problem that he set out to solve and the way he solved it. So it seems to be a bit of a confusion here. On the other hand, one hears of the purposive construction approach in the UK, where they speak of reading the entire document as one document, claims along, and then coming up with the intention that was behind the invention and construing it in that manner, and then applying it for enforcement. So these seem to be, at times, in certain cases, very opposite views. Which of these would apply?
I gotta say, I don't agree with your premise. I don't believe claims are read in isolation. At least in the United States, claims are read, quote, in light of the specification, unquote, which means that the specification breathes life into the claims. So that, in fact, definitions of terms in the specification limit the claims, in my personal understanding, so that you can, in fact, limit the claims based upon what you define a certain term to be. And remember, there's also prosecutorial estoppel. Statements made by the attorney during the prosecution of the application can limit the effect of claims as well. So I think there are many ways the claims are, in fact, limited, but they are definitely read in light of the specification. And you can disagree with me.
I agree with that, and I think where we'll see the claims separated from the specification, particularly when you're using the broadest reasonable interpretation in front of the PTAB and post-grant proceeding. I've seen some arguments made where you don't exactly have this is already after the patent is issued. And you're trying to argue the original issue claim, and there's a term that isn't exactly the way you want it, and you're trying to use something from the specification to define that term, but it wasn't it's a situation where you weren't where you were acting as a lexicographer. And so I've seen when someone tries to make an argument that, oh, okay, although my claim doesn't exactly state this, the specification states this. If you didn't act as a lexicographer and made it clear it's a valid scope, then the examiner's response will be, well, your claim doesn't state that, and we're not going to import limitations from the specification into the claim when it wasn't clear. So to that extent, I think that's the primary example where I see claims separated from the specification. But generally, the general standard is to read claims in light of the specification.
So if the claims could be interpreted in a much broader manner and thereby give you a much broader scope than what the combination of breathing life into the claim from the spec would give you, then which would apply? Would it be a broader scope that could be construed if you were to ignore the specification, or would you be limited to the narrow scope which is the result of breathing life into the claim from the specification?
In answer to that question, you got to look at it at what stage you are talking about. When you are going through the patent office during prosecution, your broadest reasonable interpretation is what is going to be the standard. Like as Bob was mentioning earlier, that's because you as a practitioner or an inventor have an opportunity to amend your claims. So the examiner will look at the claim in the broadest possible way. He's doing that to enable his search, to get the best search possible. And once you do that, On the other hand, why during enforcement, and the dichotomy is now with IPR and program proceedings, whether this is standard or fall. During enforcement by the district court, the standard is interpretation based on investigation, intrinsic evidence, etc. That's for enforcement. And unfortunately, the last 2-3 years, this dichotomy has evolved because now we have a adjudicatory body right in the patent office, which is invalidating patents left and right. And what standard do they use? Because they are a patent office body, should they use PRI? And theoretically, you can amend things, but practically it's becoming impossible to amend things. There's so much of hoops you have to jump to get, and that would be very inconsistently allowed. In fact, the patent office is allowing a parallel re-exam because practically you cannot amend claims in IPR. Even though an IPR is program proceedings going on, patent office is allowing re-examination of the same patent. So to answer your question, yeah, depends on the stage of the process that is on.
Thank you.
Yes, sir.
Unreasonably broad claim and enablement. Suppose any claim in respect of the chemical process says a process of chemical reaction with the base. Base is a very broad word. In the specification, he has also specified list of bases, and in example, he specified 1 or 2 bases. In respect of enforcement only, can that claim be limited only to those bases in respect of enablement to get the best results for which the invention has been patented or claimed as an ASPA, is restricted only to the examples?
Well, if you look at it, the moment you said it's unreasonably broad, that itself means that the claim as a whole is enabled. The claims are not interpreted such that it only covers the enableable part of the claim. Okay? A claim is enabled or not. Okay? So if you have an unreasonably broad claim, it falls on itself because part of the claim or the scope is not enabled.
Whereas there are number of solvents which probably do not enable that invention to proceed. I thought there are so many claims like that. Because you prima facie, as he rightly said, cannot input information from the specification of millimeter claim. At the time of prosecution, maybe at the enforcement, it has to be probably construed. There are many examples like that I have come across because prima facie, a small company say, oh, we are with the